Case 1. Charles Cullen. A registered nurse spent 16 years moving from hospital to hospital across New Jersey and Pennsylvania. During that time, investigators would eventually conclude that he had access to hundreds of patients and had administered unauthorized medications to a significant number of them. By the time law enforcement caught up with Charles Edmund Cullen in December of 2003, he had already left behind a trail of patient deaths that stretched across 2 states and spanned nearly 2 decades of employment at medical institutions that in many cases chose to quietly let him go rather than report their suspicions to authorities. That institutional failure is one of the most significant dimensions of this case, and it is what makes it essential viewing not just as a criminal matter, but as a public health and regulatory story. Charles Edmund Cullen was born on February the 22nd, 1960, in West Orange, New Jersey. He was the youngest of 8 children. After completing his nursing education at the Mountainside Hospital School of Nursing in Montclair, New Jersey, in 1986, he began his nursing career and worked for the next 16-plus years across at least 10 hospitals and nursing facilities in New Jersey and Pennsylvania. Colleagues and supervisors across multiple facilities documented concerns about his conduct, his access to medications, and the circumstances surrounding patient deaths during his shifts. At institution after institution, however, those concerns did not result in formal reports to licensing authorities or law enforcement. Instead, Cullen was allowed to resign or was quietly terminated and then moved on to the next facility, where the cycle began again. He crossed into Pennsylvania in 1998 and worked at multiple Pennsylvania institutions, including Liberty Nursing and Rehabilitation Center, in Allentown Lehigh Valley Hospital, at Cedar Crest in Salisbury Township near Allentown, Easton Hospital in Easton, St. Luke's Hospital in Fountain Hill near Bethlehem, and Sacred Heart Hospital in Allentown. The method investigators ultimately identified was the unauthorized injection of medications into intravenous fluid bags. The medications included digoxin, a cardiac drug, insulin, and lidocaine, a local anesthetic. Administered outside of prescribed doses and without medical authorization, these substances can cause fatal disruptions to heart rhythm and blood chemistry. Cullen's access to these medications through his nursing role allowed him to obtain and administer them in ways that, at the time, were not immediately distinguishable from natural patient deterioration, particularly in facilities caring for elderly or seriously ill populations. The first Pennsylvania case that came to the attention of investigators involved Ottomar Schramm, a 78-year-old retired Bethlehem steelworker who died at Easton Hospital. His death was recorded in December of 1998. Northampton County Coroner Zachary Lysick was alerted by the hospital's ownership in January of 1999 after toxicological analysis revealed the presence of digoxin in Schramm's blood at levels inconsistent with any prescribed treatment. Coroner Lysick, by his own later account, suspected that a pattern of deliberate patient harm might be underway. However, when the investigation proceeded, hospital officials reported that there was no internal suspect they could identify with confidence, and the case was classified as inconclusive in the year 2000. That determination meant that Cullen remained free to continue working. He moved to St. Luke's Hospital in Fountain Hill, where investigators would later link him to 6 additional Pennsylvania patient deaths. Irene Kraft, age 79, who died on June the 22nd, 2001. William Park, age 72, who died on November the 8th, 2001. Samuel Spangler, age 80, who died on January the 9th, 2002. Daniel George, age 82, who died on May the 5th, 2002. And Edward O'Toole, age 76, who died on June the 2nd, 2002. Additionally, Matthew Mattern, age 22, had died at Lehigh Valley Hospital on August the 31st, 1999, in a case also attributed to Cullen. 3 additional Pennsylvania patients, Stella Danielchek, John Gallagher, and Paul Galgon, survived what prosecutors would later characterize as attempted homicides. The case that ultimately broke the entire investigation open was not in Pennsylvania. It was at Somerset Medical Center in New Jersey, where laboratory results flagged an anomaly in a patient's medication levels that could not be explained by the patient's prescribed treatment. That report triggered a law enforcement investigation in New Jersey, which led to Cullen's arrest in December of 2003. After his arrest, Cullen began cooperating with investigators in both New Jersey and Pennsylvania. One of the most significant investigative tools that allowed prosecutors to reconstruct his access to controlled substances was the Pyxis automated medication dispensing system, a computerized cabinet used in hospitals to control and track access to medications. Records from these systems showed when Cullen had accessed medications, which medications he had accessed, and whether those access events corresponded to patient prescriptions. In multiple instances, the records showed him accessing medications for patients who had no prescription for those drugs, or withdrawing quantities that exceeded what any prescription would have justified. In Pennsylvania, Cullen pleaded guilty in Lehigh County in November of 2004 to 6 counts of murder and 3 counts of attempted murder. He was separately charged in Northampton County for the death of Audemars Schramm. Lehigh County District Attorney James Martin and Northampton County District Attorney John Morganelli both prosecuted their respective cases. Cullen's Pennsylvania public defender was Gary Astake. Sentencing in Pennsylvania took place on March 10, 2006. Northampton County Judge Stephen Barada imposed 1 life sentence without the possibility of parole for the Schramm murder. Lehigh County President Judge William H. Platt imposed 6 concurrent life sentences for the remaining 6 Pennsylvania murders, bringing the Pennsylvania total to 7 life sentences. These were added to 18 consecutive life terms already imposed in New Jersey on March 2, 2006. Charles Cullen will never be eligible for parole. The sentencing hearings were notable for events that became part of the public record. At the Lehigh County proceeding, Cullen disrupted the proceedings by repeatedly challenging the presiding judge and continuing to repeat statements after the court attempted to restore order. His public defender, Gary Astake, stated afterward that the behavior appeared to be an effort to avoid being present for the imposition of the sentence. Judge Barada, at the Northampton County proceeding, directed pointed criticism at the institutions that had employed Cullen over the years, stating from the bench that it was appalling and unconscionable that hospitals had found it easier to transfer the defendant to another facility than to address their suspicions through proper reporting channels. That institutional failure prompted direct legislative action. Governor Ed Rendell signed Pennsylvania's employer disclosure law in 2005, which required healthcare facilities to disclose employment-related misconduct by healthcare workers when providing references or verification of employment to other institutions. The law was designed specifically to close the gap that had allowed Cullen to move from facility to facility without consequence. Civil litigation followed the criminal proceedings. 8 families of patients who died at St. Luke's Hospital filed a wrongful death lawsuit in Lehigh County. In March of 2010, a jury awarded $95 million in damages against the hospital. The Pennsylvania Supreme Court denied the family's final appeal in September of 2012. The full scope of Cullen's conduct across his career has never been precisely established. He admitted to as many as 40 patient deaths across both states. Forensic investigators confirmed 29 deaths with sufficient evidentiary support to support charging. Journalist Charles Graeber, who wrote the book that became the basis for a major motion picture, characterized 400 as a conservative estimate of the total number of patients Cullen may have harmed, a figure that has never been judicially confirmed, but that reflects the difficulty of conducting retrospective toxicological investigations on patients who were already ill and whose deaths were not initially considered suspicious. What the judicial record does establish, conclusively, is that Charles Cullen was convicted of 7 murders in the state of Pennsylvania and sentenced to 7 consecutive and concurrent life terms with no possibility of parole. He remains incarcerated. The case permanently altered the regulatory framework governing how healthcare employers in Pennsylvania report concerns about nursing personnel, and it stands as one of the most consequential criminal cases in the history of the Commonwealth's healthcare system. Case 2. Heather Pressdee. In May of 2024, a Butler County courtroom heard a registered nurse plead guilty to 3 counts of first-degree murder and 19 counts of criminal attempt to commit murder. The defendant was Heather Irene Pressdee, a 41-year-old registered nurse from Natrona Heights, Pennsylvania. The sentence handed down by Butler County Court of Common Pleas Judge Joseph Cubitt was 3 consecutive life terms with no possibility of parole, plus an additional 380 to 760 years of incarceration on the attempted murder counts. It was one of the most significant criminal sentences in the history of Pennsylvania's healthcare system, and it was the product of an investigation that had begun not with law enforcement, but with a phone call from a grieving family member who did not accept the explanation they had been given for their loved one's death. Heather Pressdee was born on August 28, 1982. Before entering nursing, she spent a number of years working as a veterinary technician. She obtained her registered nursing license and began working in long-term care and rehabilitation facilities across western Pennsylvania, specifically in Allegheny, Armstrong, Butler, and Westmoreland counties. Her first nursing home position was at Encompass Health Rehabilitation in Harmarville, where she began working in October of 2018. Records from that placement showed she was disciplined for improper use of insulin, a fact that, in retrospect, investigators would identify as an early indicator of the pattern that would emerge over the following years. After Encompass Health, Pressdee moved through a series of long-term care facilities: Concordia at Rebecca Residence, Bel Air Healthcare and Rehabilitation in Lower Burrell, Quality Life Services in Shakora, Premier Armstrong Rehabilitation and Nursing Center, and Sunnyview Nursing and Rehabilitation Center in Butler. The movement from facility to facility was not, in this case, the result of terminations or forced resignations triggered by documented suspicions. It reflected, in part, the degree of staff turnover that is common in long-term care settings, particularly during and after the disruptions of the pandemic period. The investigation that ultimately led to Pressdee's arrest began when a family member of a patient who had died at Quality Life Services contacted the Pennsylvania Bureau of Narcotics Investigation and Drug Control with concerns about the circumstances of that death. The Bureau opened an inquiry and began reviewing patient records, facility medication logs, and employment documentation across the facilities where Pressdee had worked. What investigators found was a pattern. Patients at multiple facilities had experienced sudden and unexpected declines in their conditions during overnight shifts, at times that coincided with Pressdee's presence on the floor and her role managing the medication cart. Several patients died. Others were transferred to hospitals in critical condition and survived. Co-workers, in statements to investigators, described having had concerns they had not formally reported. Medical record reviews identified anomalies in patient blood chemistry that were consistent with the administration of insulin at doses not consistent with prescribed treatment plans. The medical forensics in this case centered on insulin and C-peptide testing. Insulin is a hormone that regulates blood glucose, and in medical investigations, the relationship between insulin levels and C-peptide levels in a patient's blood can indicate whether an insulin elevation resulted from the body's own production or from an external injection. If insulin levels are high but C-peptide levels are low or absent, that pattern is consistent with exogenous insulin administration. That is, insulin injected from outside the body rather than produced by the pancreas. In several of the deaths linked to Pressdee, patients who were not diabetic and had no prescribed insulin experienced sudden drops in blood glucose that were medically unexplained absent the administration of unauthorized insulin. The criminal complaint filed by the included a particularly significant element of evidence: text messages. Between April of 2022 and May of 2023, Pressdee sent text messages to her mother that investigators determined expressed intent to harm patients. The content of those messages, as described in court filings, was central to establishing the element of premeditation required for first-degree murder charges. Investigators also documented what the complaint described as a pattern of deliberate timing. Pressdee allegedly structured the administration of substances to occur before shift changes, specifically to reduce the likelihood that patients would be transferred to a hospital setting where more comprehensive toxicological testing would be performed. The complaint also described instances in which a patient showed initial signs of recovery, prompting what prosecutors characterized as a second intervention to prevent that recovery. The first charges were filed in May of 2023, covering 2 patient deaths and 1 injury. Additional charges were filed in November of 2023. Pressdee waived her preliminary hearing and was held without bail at Butler County Prison throughout the pretrial period. Investigators ultimately linked her conduct to 17 patient deaths, and Deputy Attorney General Jeffrey Baxter told the court at sentencing that 22 individuals had been identified as victims of her conduct, ranging in age from 43 to 104 years old. The 3 patients whose deaths formed the basis of the first-degree murder pleas were James Matthew Bartow, age 55, who died on December 4, 2022, at Quality Life Services in Chicora. Gerald Shrum Sr., age 90, who died on March the 25th, 2023, at Sunnyview Nursing and Rehabilitation Center in Butler. And Nicholas Symbol, age 43, who died on May the 1st, 2023, also at Sunnyview. At sentencing, Pennsylvania Attorney General Michelle Henry addressed the court and the public with a statement that emphasized the nature of the breach of professional trust at the center of the case. She stated that the defendant had used her position of trust as a means to harm patients who depended on her for care, and that while the sentence would not restore the lives lost, it would ensure that Heather Pressdee would never have another opportunity to cause harm in a care setting. Judge Cubitt imposed the sentence of 3 consecutive life terms without parole, plus the additional 380 to 760 years for the 19 counts of criminal attempt to commit murder. The plea was structured, in part, to remove the death penalty from consideration, allowing the proceedings to reach resolution without a lengthy jury trial. Following the criminal proceedings, multiple civil wrongful death lawsuits were filed against Bel Air Healthcare and Rehabilitation and Sunnyview Nursing and Rehabilitation Center by families of patients identified as victims. Those civil proceedings were ongoing at the time of reporting. The Pressdee case prompted a broader discussion within Pennsylvania's long-term care regulatory community about the protocols for insulin management in facilities that care for non-diabetic patients, the mechanisms by which coworker concerns are escalated and documented, and the oversight frameworks that govern nursing staff moving between facilities in the long-term care sector. The case drew comparisons to the Cullen case not only in terms of the method, unauthorized medication administration, but in terms of the systemic questions it raised about how facilities detect, document, and respond to patterns of patient harm. Heather Pressdee remains incarcerated. She will never be eligible for parole. The case stands as the most significant Pennsylvania healthcare criminal prosecution of the 21st century. Case 3. Kriston Gainey. The evening of April the 12th, 2018, began like any other shift at Cathedral Village, a senior living facility located in Upper Roxborough in the city of Philadelphia. The residents in the care of the night nursing staff were elderly men and women who depended on facility personnel for monitoring, assistance, and, in the event of any health concern, prompt and documented response. One of those residents was Herbert R. McMaster Sr., an 84-year-old man whose son, Herbert R. McMaster Jr., had recently served as National Security Advisor to the President of the United States. That connection would later bring significant public attention to a case that, at its core, was about a fundamental failure of documented nursing care and the legal consequences that followed. At some point during the evening of April the 12th, Herbert McMaster Sr. fell and sustained a head injury. The fall was documented. Under the facility's established protocols, any resident who sustained a fall involving a head impact was required to receive a series of neurological status checks, 8 separate assessments over the course of the hours following the incident, to monitor for signs of intracranial injury. These checks are a standard of care designed specifically to detect the development of conditions such as subdural hematomas, which can be fatal if not identified and treated promptly. The licensed practical nurse assigned to his care that night was Kriston Gainey. Gainey was approximately 30 years old at the time. According to the investigation that followed, she performed none of the 8 required neurological checks on Herbert McMaster Sr. after his fall. Herbert McMaster Sr. was found deceased in the lobby of the facility at approximately 7 in the morning on April the 13th, 2018. Philadelphia's chief medical examiner subsequently conducted an examination and determined the cause of death to be blunt impact head trauma resulting in an untreated subdural hematoma, a collection of blood between the brain and skull that, with proper monitoring and medical intervention, may have been identified and treated before becoming fatal. The investigation was triggered not by any report from Gainey, but by a nursing supervisor who, upon reviewing the documentation from the previous night's shift, noticed a serious inconsistency. The final neurological check in Gainey's records was logged at a time that followed the documented time of Herbert McMaster Sr.'s death. In other words, a check was recorded as having been performed after the patient was already deceased. That discrepancy was immediately flagged and reported. When investigators questioned Gainey, she admitted that she had falsified the documentation, that she had recorded neurological checks as completed when she had not in fact performed them. Facility surveillance camera footage reviewed during the investigation confirmed that Gainey had not entered the patient's room to conduct the required checks during the relevant time period. The documentation she had created was, in the judgment of investigators, a deliberate falsification of medical records intended to conceal her failure to provide the required standard of care. The Pennsylvania Office of Attorney General, at that time led by Josh Shapiro, announced charges against Gainey on May 10, 2018. The charges included felony neglect of a care-dependent person, involuntary manslaughter, and tampering with or fabricating physical evidence. The felony neglect charge reflected the allegation that Gainey's failure to perform the required monitoring constituted criminal neglect of a patient whose safety was her professional responsibility. The involuntary manslaughter charge reflected the allegation that her failure to monitor contributed directly to the patient's death in a manner that rose to the level of criminal culpability. The case proceeded through the legal system over the following period. Gainey ultimately reached a plea agreement with prosecutors, in which the felony neglect of a care-dependent person count and the involuntary manslaughter count were dropped. She pleaded guilty to misdemeanor neglect and to tampering with records. The sentencing imposed by the court was 6 months of house arrest and 4 years of probation. The outcome of the criminal case drew considerable public attention, in part because of the public profile of the victim's family. Advocates for patient rights and elder care standards noted that the criminal resolution was significantly less severe than the initial charges had suggested might be possible. The plea agreement, which is standard in many criminal proceedings, reflected the evidentiary and legal calculations made by both sides. In parallel with the criminal proceedings, the Pennsylvania Department of Health conducted a formal review of the facility and its practices. That review produced a report of 141 pages. The report's findings extended beyond Gainey's individual conduct to include findings about facility-level administrative failures, specifically, the failure to develop and implement a fall prevention plan appropriate to the resident population, and the failure to ensure adequate supervisory oversight of nursing staff during overnight shifts. Those findings reflected the position of regulators that the conditions enabling the lapse in care were not solely the product of one individual's decisions, but were also the product of a facility environment that did not maintain adequate safeguards. Cathedral Village, as a facility, faced regulatory scrutiny and was required to implement corrective measures. The Department of Health findings meant that the consequences of the case extended to institutional practices in a way that the criminal proceedings alone would not have addressed. Kriston Gainey's nursing license was subject to review and action by the Pennsylvania State Board of Nursing following the criminal resolution. The case remains part of the public record and is cited in discussions of mandatory incident reporting standards, documentation integrity requirements, and the regulatory frameworks that govern nursing oversight in Pennsylvania's licensed care facilities. The case of Kriston Gainey illustrates a dimension of patient harm that does not always involve intentional injury, the harm that results from documented failures of monitoring and the falsification of records that follows those failures. In the context of care for elderly and vulnerable patients, where deteriorating health conditions can develop rapidly and where timely intervention can be the difference between recovery and death, the obligation to perform and accurately document required health checks is not procedural formality. It is a core component of the duty of care. When that duty is abandoned and the records are falsified to conceal the abandonment, the law in Pennsylvania treats that as a matter warranting criminal accountability. Between Case 3 and Case 4, if you're finding this documentary series valuable, please like this video, leave your thoughts in the comments, subscribe to Hidden Case Diaries, and hit the bell icon so you don't miss any future cases. Case 4. Jacques Wagner. In October of 2022, staff and residents at Bel Air Healthcare and Rehabilitation Center in Lower Burrell, Westmoreland County, Pennsylvania, were at the center of a law enforcement inquiry that would result in one of the more straightforwardly documented criminal cases in the state's recent record of nursing personnel misconduct. The defendant was Jacques C. Wagner, a 58-year-old registered nurse from New Kensington who had been employed at the facility, which was operated by Guardian Healthcare. The charges that ultimately led to his conviction involved inappropriate sexual contact with 2 female residents in his care. The first report came directly from a resident. During what should have been a routine care interaction involving a diaper change, a procedure that is, by its nature, among the most personal and intimate of care tasks, and one that requires explicit professional boundaries and the protection of patient dignity, the resident reported that Wagner had engaged in inappropriate sexual contact. The resident's report was taken seriously, and a law enforcement investigation was initiated. During the investigation, officers interviewed Wagner. His initial account of the relevant events was that he had been assisting a female nurse during the care interaction in question, positioning himself as a supporting participant rather than the sole provider of care. That account was inconsistent with other available information, and when investigators pressed further, Wagner changed his account. He admitted that he had been alone with the resident during the care interaction, and he acknowledged the accuracy of the allegations against him. A second victim was identified in the course of the investigation. That resident had not come forward initially, for reasons that, as the case record reflected, were consistent with the documented reluctance of vulnerable care facility residents to report misconduct by the staff upon whom they depend for daily care. The investigation proceeded to encompass both individuals, and the evidentiary record developed to support the charging of Wagner with multiple offenses. The charges filed against Jacques Wagner included aggravated indecent assault, a felony offense, along with related misdemeanor charges, abuse of a care-dependent person, and additional counts of indecent assault. He was arrested and released on $25,000 bond while the case proceeded through the courts. Wagner ultimately entered a guilty plea to 6 of the charges against him. The case was resolved without a jury trial. Sentencing was conducted by Westmoreland County Court of Common Pleas Judge Megan Billick DeFazio. Judge Billick DeFazio imposed a sentence of 6 to 23 months of incarceration, followed by 10 years of probation. In addition to the custodial and supervisory terms of the sentence, Judge Billick DeFazio imposed 2 conditions of particular significance to the protection of future patients. Wagner was permanently barred from employment at any care facility or in any role involving care for vulnerable populations, and he was required to forfeit his nursing license. The forfeiture of his nursing license meant that Wagner could not apply for reinstatement through the standard licensing process. The lifetime employment bar from care facilities added a layer of protection beyond what license forfeiture alone would provide. Recognizing that individuals who have committed patient misconduct sometimes seek employment in care-adjacent roles that do not technically require a nursing license, but that nonetheless bring them into contact with vulnerable individuals. The Bel Air Healthcare and Rehabilitation Center was the same facility where, investigators would later document, Heather Pressdee, whose case is covered in Case 2 of this series, had also worked. The facility's operations and oversight practices drew regulatory scrutiny in connection with both cases. The 2 cases, while factually and legally distinct, illustrate the importance of facility-level oversight mechanisms in identifying and responding to personnel misconduct before it escalates or affects additional patients. The Wagner case is significant in the context of this documentary series, as one of 2 cases covered here involving inappropriate conduct of a sexual nature by nursing personnel toward residents of care facilities. The Octavia Robinson case, covered in Case 9, involved a different type of inappropriate physical conduct. Together, they represent a category of patient harm that is distinct from the medication-related misconduct at the center of most of the other cases in this series, but that is equally a matter of criminal law and professional accountability. For the 2 residents who reported and whose reports were investigated and credited by law enforcement and the court, the resolution of the case brought a formal judicial acknowledgement that what occurred was not an ambiguity or a misunderstanding, but a criminal violation of their rights and safety as care-dependent persons under Pennsylvania law. Jacques Wagner was convicted, sentenced to incarceration, placed on a decade of supervised probation, and permanently barred from working in the profession he had practiced. He will not hold a nursing license again. The case also illustrates the role of patient reporting in the enforcement of standards within care facilities. The investigation in the Wagner case was initiated because a resident came forward. Care facilities in Pennsylvania are required to maintain processes for residents to report concerns and to ensure that those reports are taken seriously and referred to appropriate authorities. The Wagner case is a documented example of that process functioning as intended. A resident reported, the report was investigated, charges were filed, and a conviction was obtained. Case 5. Dana Aldinger. The case of Dana Aldinger which was resolved in the federal courts of the Middle District of Pennsylvania in 2022, represents a category of nursing personnel misconduct that healthcare regulatory agencies across the United States identify as a persistent and serious concern: the diversion of controlled substances that are prescribed to patients in the care of the nurse responsible for administering them. In this instance, the controlled substance at issue was oxycodone, an opioid painkiller, and the patient from whom it was diverted was an individual receiving hospice care, one of the most medically and emotionally vulnerable categories of patient. Dana Aldinger was 55 years old at the time of her sentencing. She had worked as a licensed practical nurse and also in an administrative capacity at a personal care home for seniors in York, Pennsylvania, specifically in Springettsbury Township. The conduct at issue occurred on or around August the 10th, 2019. The hospice patient in question was receiving oxycodone as part of a Medicare-covered hospice care plan. The medication was prescribed and documented as part of the patient's pain management and comfort care protocol. Aldinger, in her role at the facility, had access to the patient's medications as part of her nursing responsibilities. According to the federal criminal information filed against her, she diverted at least 15 pills of the patient's oxycodone, removing them from the supply that was intended for the patient's authorized medical use, and then falsified medical records to conceal what she had done. Falsification of medication records in a setting like this serves a specific and significant concealing function. Controlled substances in healthcare settings are subject to count verification, meaning that the documented quantity of a medication is periodically reconciled with the physical quantity remaining. If medications are removed without documentation, the discrepancy will eventually surface in a count. By falsifying records to reflect that the medications had been administered or disposed of in accordance with proper procedure, Aldinger created a paper record designed to prevent the discrepancy from being identified. The investigation was conducted by the United States Department of Health and Human Services Office of Inspector General through its Harrisburg field office in coordination with the Pennsylvania Bureau of Narcotics Investigation. The involvement of the HHS Office of Inspector General reflected the federal dimension of the offense. The patient's hospice care was funded through Medicare, a federal health care program, meaning that the theft of medication intended for that patient was not only a theft of the medication, but an act that implicated the integrity of the federal health care program funding the patient's care. The case was prosecuted as a federal offense, theft in connection with health care under the Federal Criminal Code. Aldinger waived her right to a formal grand jury indictment and instead entered a guilty plea by criminal information in December of 2021. Sentencing took place on May 23, 2022, before United States Magistrate Judge Martin C. Carlson in the Middle District of Pennsylvania. The prosecution was handled by the Office of United States Attorney John C. Gerganis, with the case litigated by Assistant United States Attorney Samuel S. Dalkey. At sentencing, Judge Carlson imposed a sentence of 1 year of probation and a monetary fine of $525. In addition to the judicial sentence, Aldinger permanently surrendered her nursing license, meaning she would not be eligible to practice as a licensed practical nurse in Pennsylvania or in any other state that recognized her surrender as a basis for denial of licensure. The outcome of the Aldinger case illustrates several features of how controlled substance diversion cases in healthcare settings are typically handled in the federal system. Prosecutions of this type, when they involve first-time offenders and do not involve direct patient harm of a documented physical nature, frequently result in non-custodial sentences focused on deterrence, professional consequences, and supervised compliance. The permanent license surrender is, in practical terms, the most significant long-term consequence for a nursing professional convicted of this type of offense, as it removes the ability to practice in the profession that provided access to the controlled substances in the first place. The patient who was deprived of their oxycodone was a hospice patient, an individual in end-of-life care, for whom pain management is among the primary medical priorities. The regulatory and legal systems governing controlled substance management in hospice and long-term care settings exist precisely to protect this category of patient, whose capacity to advocate for their own care may be significantly limited and whose medication needs are acute. The Aldinger case, while involving a single identified victim and a relatively limited quantity of medication compared to some of the other cases in this series, is representative of a documented pattern that healthcare regulatory bodies across the United States have identified as a significant systemic problem. According to the Drug Enforcement Administration and the HHS Office of Inspector General, medication diversion by healthcare workers is one of the most common forms of healthcare fraud and professional misconduct in the nursing and allied health professions. The prosecution and federal conviction of Dana Aldinger for this conduct and the consequent permanent surrender of her nursing license reflect the legal system's response to that pattern at the individual case level. Case 6. Deborah Shook. The case of Deborah A. Shook, a registered nurse employed in the post-anesthesia care unit of Butler Memorial Hospital in Butler County, Pennsylvania, was initiated following a patient complaint that was reported in August of 2022. The complaint came from a patient who had been in Shook's care and who reported an experience that, upon investigation by hospital administrators and subsequently by law enforcement, was found to be supported by significant physical and documentary evidence. Charges were formally filed by the Pennsylvania Office of Attorney General in May of 2023. Deborah Shook was 55 years old at the time the charges were filed. She had been working in the post-anesthesia care unit, commonly referred to in hospital settings as the PACU, a specialized environment where patients recovering from surgical procedures are monitored and receive pain management and supportive care during the period immediately following anesthesia. Access to powerful pain medications, including opioids, is a standard feature of PACU nursing practice, and nurses in this setting are expected to document all medication administration with precision and to reconcile their documentation against the physical supply at the end of each shift. The conduct at issue involved Dilaudid, the brand name for hydromorphone, a potent opioid analgesic. According to the investigation, in August of 2022, a patient in Shook's care reported not receiving adequate pain medication. In the context of this report, the patient also described having observed Shook in the act of handling medication in a manner inconsistent with standard administration practices, specifically, placing syringes of medication in her pocket before administering what the patient received. The hospital initiated an internal investigation. Investigators reviewing the documentation found records indicating that Dilaudid had been administered to patients at times and in quantities reflected in the nursing records. But physical examination of the unit found the medication in a location where it should not have been if it had in fact been administered as documented. Specifically, Dilaudid that was recorded as having been administered was instead found at Shook's desk. This discrepancy between the documented record and the physical presence of the medication constituted what investigators characterized as falsified medical records, a documentation of administration that had not, in fact, occurred. In the course of the internal investigation, Shook was required to provide a urine sample for toxicological analysis. That analysis returned positive results for hydromorphone, the active compound in Dilaudid, as well as for fentanyl, another opioid. The presence of these substances in her system was consistent with personal consumption of the medications and was inconsistent with incidental or accidental exposure through routine nursing duties. The Pennsylvania Office of Attorney General filed charges against Shook in May of 2023. The charges included felony possession of a controlled substance obtained by misrepresentation or fraud, felony furnishing false information to obtain a controlled substance, misdemeanor theft, and misdemeanor endangerment of a care-dependent person. The felony charges reflected the mechanism by which Shook allegedly obtained the medication, by creating false documentation suggesting the medication had been used for patient care when it had not, a practice that constitutes a form of fraud against both the healthcare institution and the regulatory system governing controlled substance distribution. The endangerment of a care-dependent person charge reflected the direct consequence for patients. Individuals in a post-anesthesia care unit who do not receive their prescribed pain medication following a surgical procedure are not simply experiencing an inconvenience. In the immediate post-surgical period, adequate pain management serves both comfort and clinical functions, and the failure to administer prescribed pain medication can have documented clinical consequences. The evidence assembled in this case across three distinct categories: patient testimony documenting an anomaly in medication handling, falsified documentation with a physical discrepancy that disproved its accuracy, and toxicological confirmation of personal consumption, represents a fairly comprehensive evidentiary structure for a medication diversion case. Each element independently supports the allegations. Taken together, they constitute a mutually reinforcing body of evidence. At the time of the documentary research underlying this case segment, the disposition of the charges against Deborah Shook, whether through a plea agreement, a trial verdict, or some other legal resolution, had not been publicly confirmed. Viewers and researchers who wish to determine the current status of this case are encouraged to consult the Butler County Court of Common Pleas docket, which maintains public records of case proceedings, or to review announcements from the Pennsylvania Office of Attorney General. The Shook case is significant to this documentary series as an illustration of how medication diversion investigations in hospital settings are typically constructed. The starting point in this case was a patient complaint. That complaint prompted an internal hospital investigation. The internal investigation identified a documentary discrepancy. Physical evidence. The medication found at a location inconsistent with administration corroborated the discrepancy. Toxicological testing then provided biological evidence consistent with personal consumption. The resulting case was built on multiple, independently verifiable evidentiary pillars rather than on a single witness or a single piece of documentation. This layered evidentiary approach is increasingly characteristic of controlled substance diversion investigations in regulated healthcare settings, reflecting both the complexity of proving intent in cases where the defendant's role gives them legitimate access to the substances at issue, and the availability of multiple types of documentation and physical evidence that can be cross-referenced to identify inconsistencies. Case 7. Ashley Miller. The case of Ashley Laura Miller, a registered nurse employed by Amedisys Home Health and Hospice Care, originated in Carbon County, Pennsylvania, in Penn Forest Township, and was the subject of a state police investigation initiated in February of the year in which the conduct was discovered. Miller was 36 years old at the time she was charged. The conduct at issue involved the disappearance of a significant quantity of controlled substances, specifically oxycodone and Ativan, from the home of a terminally ill hospice patient, along with evidence that Miller had taken those medications from the patient's supply while representing to the patient's family that she was performing an authorized medication disposal. Home hospice nursing involves a fundamentally different operational environment from institutional nursing. There are no other staff members present to observe medication handling, no automated dispensing systems reconciling access to controlled substances against electronic prescription records, and no surveillance cameras monitoring nurse-patient interactions. The nurse enters a private home, often interacts with a patient who is near the end of life and whose capacity to monitor their surroundings may be significantly diminished, and manages medications that include powerful controlled substances, frequently opioids, that are prescribed specifically for end-of-life comfort care. The accountability mechanisms that do exist in home hospice nursing include prescription monitoring programs, medication count documentation, and agency-level oversight procedures that require nurses to account for controlled substances they have dispensed or, in the case of patient deaths, disposed of, according to regulatory protocol. It was the failure of the accounting for those medications in the Miller case that triggered the investigation. The patient to whom the medications had been prescribed died. Following the patient's death, another nurse associated with the case identified that a significant quantity of medications was missing from the patient's supply. 200 tablets of oxycodone and 30 tablets of Ativan were unaccounted for. Amedisys conducted an internal review of the case documentation and identified chart discrepancies, inconsistencies in the record that suggested dates had been altered. Miller had told the patient's family that she would take the patient's medications to be disposed of. The medications disappeared. The documentation was inconsistent. An account of 230 missing controlled substance tablets represented a discrepancy that exceeded any margin of accounting error. The Amedisys Director of Operations contacted the Pennsylvania State Police on February the 12th. An investigation was opened. When investigators sought to speak with Miller and requested that she submit to a drug test, Miller refused the drug test and was terminated from her position at Amedisys. The refusal to submit to a drug test did not constitute an admission of wrongdoing, but it was a documented fact in the record of the investigation. The Pennsylvania Attorney General's Prescription Monitoring Program, a statewide database that tracks the prescribing and dispensing of controlled substances, was consulted as part of the investigation. This program, which exists in nearly every state in the United States, allows investigators to cross-reference a patient's prescription history with dispensing records to identify potential discrepancies between what was prescribed, what was dispensed, and what documentation reflects as having been used or disposed of. Carbon County District Attorney Mike Greck reviewed the evidence and authorized felony theft charges against Miller. She was arraigned on May the 22nd, with bail set at $5,000, and a preliminary hearing was scheduled to proceed in the following weeks. The charges against Ashley Laura Miller were pending at the time the research underlying this documentary was conducted. Viewers and researchers seeking the current status of this case are encouraged to consult the Carbon County Court of Common Pleas docket or announcements from the Carbon County District Attorney's Office. All charges at the time of reporting were allegations, and Miller is presumed innocent unless and until she is found guilty by a court of competent jurisdiction. The Miller case illustrates several features of the regulatory and investigative landscape around home hospice nursing and controlled substance diversion that are worth understanding in their proper context. Home hospice nurses occupy a position of significant trust in one of the most vulnerable care environments that exists, the home of a dying person, surrounded by family members who are managing grief and end-of-life logistics simultaneously. The medications involved, oxycodone and Ativan, are controlled substances with significant street value and with documented abuse potential. The accountability framework governing their disposition after a patient's death is specific, and its integrity depends substantially on the honesty of the nurses who manage it. The fact that the investigation in this case began with a routine post-death medication accounting, conducted by another nurse, not by law enforcement, illustrates the importance of internal agency oversight as a first line of detection in home care settings where external observation is limited. The referral to state police, the engagement of the prescription monitoring program, and the district attorney's authorization of charges illustrate how an internal agency finding transitions into a law enforcement investigation and ultimately into criminal accountability. Case 8. Tom Nyakariga. The case of Tom Nyakariga, a licensed nurse at Abbeville Skilled Nursing and Rehabilitation Center in Lancaster, Pennsylvania, came to the attention of law enforcement in early 2025 after a witness made a report to the Lancaster County Office of Aging. What the report described, and what the subsequent investigation confirmed, was a pattern of medication theft from a resident of the facility that had been ongoing for a period of several months, accompanied by a deliberate effort to conceal the theft by destroying the identifying information on the medications that had been taken. Tom Nyakariga was 50 years old at the time he was charged. He had been employed as a licensed nurse at Abbeville Skilled Nursing and Rehabilitation Center, a long-term care facility in Lancaster that provides nursing and rehabilitative services to adults who require ongoing medical support. In that role, he had access to the medications of residents in his care, a standard feature of nursing practice in residential care facilities, where licensed nursing staff administer medications to residents on schedules determined by physician orders and facility protocols. According to the charging documents, the conduct at issue began in June of 2024 and continued through January of 2025, a period of approximately 7 months during which Nyakariga is alleged to have removed non-narcotic medications from the supply of a 77-year-old patient in the facility's care. The medications involved were not controlled substances of the type at issue in several of the other cases in this series. They were non-narcotic prescription medications. However, the theft of any prescribed medication from a patient in a care facility constitutes a harm to that patient, who is deprived of medications that a physician has determined they need and who may experience adverse health consequences as a result of the interrupted treatment. The method by which Nyakariga allegedly concealed the theft involved physical alteration of the medications themselves. According to investigators, he removed the medications and then obscured the identifying information on the prescription labels, specifically blacking out the patient's name, before destroying the product information that accompanied the medications. This approach was designed to prevent the medications from being identified and traced back to the patient from whom they had been taken, and to eliminate the documentation that would allow an investigator to reconstruct what had been removed. The discovery of the conduct did not begin with a formal audit or a medication count discrepancy identified within the facility. It began when a witness, an individual not employed by the facility in the relevant capacity, found the medications in Nyakariga's home and recognized that their presence there was inconsistent with any legitimate explanation. That witness reported the finding to the Lancaster County Office of Aging, which is the county agency responsible for overseeing the welfare of older adults and investigating allegations of elder abuse and neglect. The Lancaster County Office of Aging assessed the report and referred the matter to Lancaster Township Police, who have jurisdiction over the geographic area in which the investigation was appropriate to be conducted. The police investigation proceeded on the basis of the witness report and the physical evidence the witness had identified, and charges were filed in early February of 2025. The charges brought against Tom Nyakariga were misdemeanor neglect of a care-dependent person and misdemeanor theft by unlawful taking. The neglect charge reflected the conclusion that removing medications from a patient's supply, resulting in that patient going without medications a physician had ordered for their care, constitutes neglect of a care-dependent person under Pennsylvania law. The theft charge reflected the straightforward taking of property, in this case prescription medications, that did not belong to Nyakariga. The characterization of medication theft from a care facility resident as neglect, rather than simply theft, reflects a feature of Pennsylvania's criminal code that recognizes the special vulnerability of care-dependent persons and the special duty of care that nursing personnel owe to them. Under this framework, a nurse who takes a patient's medication is not merely committing theft in the conventional sense. They are also failing a duty of care that their professional and employment relationship requires them to fulfill. The dual charges capture both dimensions of the conduct. At the time the research underlying this documentary was conducted, the charges against Tom Nyakariga were pending in the Lancaster County court system. He is presumed innocent unless and until found guilty by a court of competent jurisdiction. Viewers and researchers seeking the current status of this case are encouraged to consult the Lancaster County Court of Common Pleas docket. The Nyakariga case, while involving non-narcotic medications and misdemeanor rather than felony charges, illustrates a form of patient harm that can be difficult to detect in long-term care settings. The gradual, ongoing diversion of a resident's medications by a staff member with routine, legitimate access to those medications. The concealment method, obscuring the prescription labels and destroying product information, reflects an awareness that the medications could be identified if found, and a deliberate effort to prevent that identification. The fact that the case was ultimately discovered through a witness report rather than through facility monitoring processes underscores the role of community members and facility-adjacent individuals in the oversight ecosystem that protects vulnerable care facility residents. Case 9. Octavia Robinson. On June the 23rd of the relevant year, the Northampton County facility known as Graysdale Nursing Home, located near Nazareth, Pennsylvania, was the subject of a law enforcement response following a call reporting that a nurse was acting in an unusual manner and had remained in a resident's room for approximately 2 hours while declining to leave. When officers responded to the welfare check, they encountered a situation that resulted in the arrest and criminal charging of Octavia Robinson, a 43-year-old nurse from Morristown, New Jersey, who had been hired at the facility on June the 11th of that year, less than 2 weeks before the incident. The officers who arrived at the facility found Robinson standing over a patient. Robinson was using her fingers in a manner that was immediately concerning to the responding officers, and she told them that there were demons inside the patient that she needed to remove. Upon being directed by law enforcement to stop what she was doing, Robinson complied. She was taken into custody and transported to a hospital for an involuntary emergency psychiatric evaluation under the relevant Pennsylvania statutory procedures governing emergency mental health intervention. The circumstances of the incident, the duration of Robinson's presence in the room, the nature of what responding officers observed, and the explanation she provided were documented in the police report as the factual basis for the charges that followed. The patient was assessed for any injury or harm that may have resulted from the incident. Charges filed against Octavia Robinson included abuse of a care-dependent person, simple assault, and harassment. The abuse of a care-dependent person charge reflects the Pennsylvania statutory framework that provides enhanced protection for individuals in care facilities who, by reason of their age, disability, or medical condition, are in a position of vulnerability relative to the staff entrusted with their care. A care-dependent person, under Pennsylvania law, is one who relies on nursing or personal care assistance for daily functions. and the statute makes it a criminal offense for caregivers to abuse them. Graysdale Nursing Home, where the incident occurred, is a county-operated facility managed by Northampton County. At the time of the incident, Robinson had been employed there for 12 days. Following the incident, she was no longer employed at the facility, and a warrant was requested in connection with the charges. The circumstances of the Robinson case, as documented in the publicly available reporting, raise questions about the pre-employment screening processes for nursing personnel at care facilities. Specifically, the degree to which background checks, reference verification, and licensing status confirmation are conducted before a nurse is placed in direct contact with vulnerable residents. Robinson's arrival from New Jersey, her very brief tenure before the incident, and the nature of the behavior observed by law enforcement are all factual elements of the documented record. At the time the research underlying this documentary was conducted, the charges against Octavia Robinson were pending. She is presumed innocent of the charges against her unless and until she is found guilty by a court of competent jurisdiction. Her case was subject to the evaluation of her mental health status at the time of the incident, which is a legally relevant consideration in any criminal proceeding where the defendant's mental state during the alleged conduct is at issue. Pennsylvania law provides procedures for the evaluation of a defendant's competency to stand trial and for the assessment of a mental health defense where applicable. Viewers and researchers seeking the current status of the Robinson case are encouraged to consult the Northampton County Court of Common Pleas docket or contact the Northampton County District Attorney's Office. The Robinson case is unlike any other in this documentary series in terms of the nature of the alleged conduct and the circumstances under which it was observed. While most of the cases covered in this series involve the covert diversion of medications or covert administration of unauthorized substances, the Robinson incident was observed in real time by responding law enforcement officers who had been called specifically because of concerns about what was occurring. The evidentiary record, in that sense, is anchored by direct law enforcement observation rather than retrospective forensic reconstruction. The case also illustrates the critical function of the welfare check, a law enforcement mechanism that allows concerned individuals, whether family members, facility staff, or other residents, to request a police response when they observe something that causes them concern about a person's well-being. In the Robinson case, the welfare check mechanism was activated by a caller who observed that a nurse was behaving in a manner that raised concerns and was refusing to leave a resident's room. The response of law enforcement to that call was direct, timely, and resulted in an intervention that ended the incident. The role of other facility staff in situations like this, their ability to recognize that something is wrong, their willingness to report it, and the institutional processes available to them for doing so, is a recurring theme across the cases in this documentary series. In the Robinson case, the reporting mechanism was a direct call to law enforcement. In other cases, such as the Pressdee case, concerns were communicated through less formal channels before law enforcement became involved. Case 10, Shannon Womack. The case that came to public attention in April of 2025, involving the individual charged under the name Shannon Nicole Womack, represents a category of patient harm that is both distinctive in its operational complexity and deeply concerning in its implications for the integrity of credentialing and background check systems in the long-term care industry. The defendant, whose true legal identity remained unconfirmed by law enforcement at the time of reporting, she was also known to use the surnames Robinson and Parham, as well as approximately 20 other aliases and 7 social security numbers, is alleged to have systematically assumed the identities of 4 real, licensed nurses from southern states, obtained employment at multiple Pennsylvania care facilities without holding any genuine nursing license, and used that fraudulently obtained access to divert controlled substances from vulnerable residents. The scheme, as documented in the 43-count criminal complaint filed by the Pennsylvania State Police in coordination with Washington County District Attorney Jason Walsh, appears to have begun around the year 2020, a period that, as investigators noted, coincided with significant staffing pressures in the long-term care industry during and immediately following the COVID-19 pandemic. Facilities across Pennsylvania and the country face significant challenges maintaining adequate nurse staffing during this period, and the urgency of filling positions may have, in some instances, affected the thoroughness of pre-employment credentialing verification. The facilities identified in the charges included Cornerview Nursing and Rehabilitation Center, Southmont of Presbyterian Senior Care in Washington County, and St. Mary's Home of Erie in Erie County. At these facilities, the individual charged as Shannon Womack allegedly presented herself not only as a licensed practical nurse, but in some instances as a registered nurse and as a registered nurse supervisor, a managerial role that would have given her authority over other nursing staff in addition to direct patient care responsibilities. The stolen credentials she allegedly used belonged to 4 real nurses from southern states. Those nurses, individuals who had lawfully obtained their licenses and whose professional identities were appropriated without their knowledge or consent, may themselves have faced consequences as a result of their identity information being used in fraudulent employment applications, depending on how facilities, licensing boards, and background check systems recorded and tracked the fraudulent use of their credentials. The conduct that forms the core of the criminal charges extends beyond the identity theft and fraudulent employment itself. At Southmont of Presbyterian Senior Care, investigators determined that more than 125 milligram oxycodone tablets had gone missing from the facility's controlled substance supplies. 5 residents were identified as having been affected by the missing medication. The disappearance of oxycodone, a scheduled opioid with significant street value and documented abuse potential, from the supplies of 5 separate patients, represents a significant diversion event, both in terms of patient harm and in terms of the institutional accountability failures it implies. The case was broken not by a credentialing audit or a medication discrepancy flag within a facility, but by a traffic stop. In April of 2025, Pennsylvania State Police stopped a vehicle in Cecil Township, Washington County, in the course of a routine traffic enforcement action. When the driver, the individual alleged to be Shannon Womack, presented identification, officers discovered that the identification was connected to active warrants. A search of the vehicle produced a substantial quantity of physical evidence, multiple forms of identification, medical records, patient care logs, and prescription medications that appeared to belong to facility residents rather than to the driver. The 43 counts charged against the defendant included corrupt organizations, endangering the welfare of a care-dependent person, identity theft, forgery, theft by unlawful taking, unlawful use of a computer, and drug paraphernalia charges. The corrupt organizations count, drawn from Pennsylvania's organized crime statute, a provision typically associated with criminal enterprises rather than individual offenders, reflects the systematic, multi-facility, multi-year nature of the alleged conduct. The defendant was denied bail by the arraigning judge, who found her to be a flight risk, given the active warrants from Georgia, Tennessee, New Jersey, and Indiana that were also pending against her, along with the multi-state, multi-identity nature of the alleged conduct. Bail was set at $250,000, and she was held at Washington County Jail. The Womack case exposes a significant vulnerability in the healthcare credentialing ecosystem. Nursing licenses are issued by state boards of nursing and are theoretically verifiable by any employer through the relevant state board's online verification system. The ability to pass credentialing checks using stolen credentials belonging to real nurses rather than entirely fictitious individuals reflects a gap in how verification systems function in practice. A stolen identity that corresponds to a real, currently active nursing license may, absent additional verification steps, appear to clear a standard verification inquiry, particularly if the real license holder has not been alerted that their credentials are being misused. The case has prompted discussions among long-term care regulatory advocates and healthcare credentialing professionals about what additional verification steps, such as identity document authentication, in-person credentialing interviews, or cross-referencing with national databases that track disciplinary actions and license suspensions, might reduce the vulnerability to this type of scheme. At the time the research underlying this documentary was conducted, all charges against the individual charged as Shannon Nicole Womack were allegations. She is presumed innocent unless and until found guilty by a court of competent jurisdiction. The case was pending in the Washington County court system. Viewers and researchers seeking updates on the current status of this case are encouraged to consult the Washington County Court of Common Pleas docket or announcements from the Washington County District Attorney's Office and the Pennsylvania State Police. The case of Shannon Womack brings this documentary series to its conclusion, with a case that is, in some respects, the most legally complex of the 10. It involves not a licensed nurse who violated the duties of a license they legitimately held, but an individual who allegedly obtained access to vulnerable care facility residents by falsely assuming the professional identities of real nurses, and then used that fraudulently obtained access to deprive patients of medications they needed and to divert controlled substances for purposes unrelated to patient care.